So what should be the next step in this case? Let's examine the 8 examples provided in the handbook. Starting with the first example, we have Alan, who works at an investment bank. Alan discovers that his company's financial statement submitted to the regulator overestimated the amount of revenue for their customers in the third quarter. He realizes that one of his clients has false or inflated figures in the financial statement. In this situation, Alan takes action by seeking professional legal advice within the company. However, the legal counsel provides a vague response indicating that the regulator cannot determine Alan's involvement in any wrongdoing, implying that he shouldn't be concerned. It is important to note that seeking legal advice, including in-house counsel, is recommended by our association. However, simply relying on this advice does not absolve one of responsibility. In such a case, it is crucial to report the situation to one's supervisor and seek independent legal advice. This recommendation stems from the uncertainty and potential bias of in-house counsel's response. Additionally, it is necessary to assess whether reporting the wrongdoing to the regulator is appropriate in the specific circumstances. While our guidelines do not mandate reporting to a government agency, it is crucial to consider the potential impact on the market and the integrity of the capital market as a whole. Analyzing the specific situation on a case-by-case basis is essential to determine the appropriate course of action. This example serves to highlight the importance of seeking independent legal advice, reporting the situation to a supervisor, and evaluating the need for reporting the misconduct to the regulator based on the specific circumstances. Let's explore the second example, which involves dissociation when a violation of the law is discovered. In this case, the protagonist is Brown, who also works in investment banking. Brown's firm is the lead underwriter for Company C's stock offerings. However, Brown uncovers that the serious losses incurred by one of Company C's overseas operations in the third quarter were concealed. The public data and prospectus distributed by Brown's employer do not reflect these losses. Given this situation, it is crucial to consider the following comments. Firstly, Brown should immediately report the incident to the appropriate regulatory personnel within the company. This aligns with the step of reporting to the boss as mentioned earlier. If reporting within the company does not yield satisfactory results or the employer is involved in fraudulent underwriting practices, Brown should dissociate from all ties with the business. Similar to the first example, in addition to dissociation, Brown should also consider seeking legal advice and potentially taking further actions, such as making additional reports, based on the specifics of the situation. Overall, this example emphasizes the importance of promptly reporting the misconduct, dissociating oneself from the wrongdoing, seeking legal advice, and evaluating the need for further actions based on the circumstances at hand. Now, let's examine the third case, which also emphasizes disengagement. In this scenario, we have Washington, who works for a company that attracts customers by showcasing the returns of a combination of accounts over the past decade. However, Washington discovers a significant issue: the portfolio fails to account for the performance of a terminated investment account. It is common knowledge that when a fund performs poorly, it may be closed. For instance, let's consider a fund that experienced substantial losses and was terminated in the first half of this year. Logically, when presenting the performance of the composite over the past decade, the returns should include the losses incurred by this fund. Unfortunately, the company neglects to include this information, leading to an overstatement of the overall performance figures in their external communications. Once Washington becomes aware of this mistake, he faces additional pressure from his boss, who instructs him to present the results as they are. Now, when it comes to conducting business externally, the boss expects Washington to use the numbers recently announced by the company for the past decade. However, Washington knows that the chosen figures are clearly inflated. It is important to note that in this case, Washington's compliance with the boss's request would violate our CFA Code of Conduct. It not only breaches the knowledge of law, but also the third rule regarding misrepresentation. which will be discussed later. By presenting false figures to the outside world, Washington engages in misstatement and misrepresentation. Moreover, his actions potentially violate multiple rules simultaneously, which is not uncommon in such situations. If Washington were to comply with the boss's request and present the business externally with inaccurate figures, he would clearly be in violation. Now, let's consider what Washington should do in this situation. As we have previously discussed, disengagement is key. In terms of specific steps, he should initiate a discussion with the relevant business leader responsible for calculating the investment return. Additionally, Washington should report the matter to his supervisor or the company's compliance department. Furthermore, if the company refuses to recalculate the performance figures, Washington must adhere to his principles. He should avoid using misleading material and explain to the company why he cannot comply with the request. Washington should provide factual information and justifications for his decision, ensuring that he is seen as a professional who acts in accordance with ethical standards. Ultimately, if the company insists on using the incorrect material and disregards Washington's objections, he should consider the significance of this matter. It may be necessary for him to resign, as sticking to his principles and maintaining professional integrity are of paramount importance. In the fourth example, Colin works for a large investment bank in the United States, but he is located in a developing country with an imperfect legal system. The local securities laws in his country are relatively simple and do not explicitly prohibit insider trading. However, as a CFA charter holder, Colin must abide by the CFA Code of Conduct, which prohibits insider trading. Since his employer is based in the United States, where insider trading is explicitly prohibited, Colin is bound by both the local laws and the stricter regulations outlined in the CFA Code of Conduct. Therefore, he cannot engage in insider trading, even if it is not explicitly banned in his country. Moving on to the fifth example. Jensen works for a multinational investment advisory firm in the United States, but resides and works in a small island nation. The securities laws in the island nation prohibit investment advisors registered and operating in the country from participating in an initial public offering (IPO) with an individual account. Although the CFA Code of Conduct allows investment advisors to participate in IPOs with client accounts, Jensen must adhere to the stricter regulations of the island nation where he is conducting business. He cannot solely rely on the laws of his employer's country or the CFA Code of Conduct. Thus, Jensen should comply with the island nation's rules and avoid participating in the IPO with an individual account, despite his U.S. citizenship and employment with an American firm. In the sixth example, Jenny is an investment manager responsible for a hedge fund. The firm receives an investment letter from a potential customer in the Middle East who seeks investments compliant with Islamic law. However, the firm's promotional materials do not explicitly state whether the fund aligns with Islamic law. Jenny recognizes the importance of detailed disclosure to minimize potential risks, given the client's preference. In this case, Jenny should ensure that the fund's compliance with Islamic law is explicitly disclosed to potential investors from the Middle East who adhere to those principles. These examples highlight the importance of understanding and complying with the relevant laws and regulations based on the specific circumstances. As CFA members or candidates, it is crucial to consider cultural, religious, and legal differences in the regions where business is conducted. Familiarizing oneself with these factors helps ensure adherence to the strictest standards and mitigate potential risks. In the seventh example, the story revolves around Bloom, a junior investment portfolio manager in a global fund company. The company has new customers from a foreign country, and there is a local supervisor responsible for the operations in that country. The supervisor has received a significant amount of money from the company and is supposed to use it to purchase third-party research services in country A. However, Bloom notices that the portfolios under the supervisor's management are not invested in the market of country A, and there are no research reports produced by the supervisor. This raises suspicion that the money might have been misappropriated instead of being used for its intended purpose. Bloom consults with his boss and expresses doubts about the supervisor's behavior. However, the boss informs Bloom that the purchased research reports have indeed been obtained from the local supervisor, suggesting that the money was used as intended. Despite the explanation, Bloom remains skeptical and believes that the supervisor might have embezzled the company's money. In such a situation, it is advisable for Bloom to consult legal professionals, whether internal or external, to seek guidance on how to address the suspected misconduct. Merely reporting the concerns to a superior may not be sufficient, especially if there is a possibility of collusion within the organization. Engaging individuals with regulatory powers or escalating the issue to a higher level of authority may be necessary to thoroughly investigate and resolve the matter. The key takeaway from this example is to prioritize following the appropriate channels and seeking professional guidance when suspicions of illegal or unethical behavior arise. The ultimate goal should be to address the issue effectively and ensure that one is not implicated or involved in any wrongdoing.